Welcome to The Explainer. Today, we're diving into a wild, real-life legal chess match straight from the Constitutional Court of South Africa. We are talking about the case of Brummer versus Gorfil Brothers Investments. I want you to imagine suing someone, thinking you have an absolutely rock-solid case, only to have the defendants figure out a way to legally buy your lawsuit out from under you just to shut it down. It's a brilliant, ruthless, and absolutely fascinating piece of legal maneuvering that's still referenced today as a literal masterclass in procedural loopholes. It really forces us to question just how far the rules of litigation can be stretched before they completely break.
Okay, let's dive into this. Can you actually buy a lawsuit just to terminate it? I mean, it sounds totally impossible, right? It sounds entirely made up, like some convenient plot point written for a Hollywood legal thriller to corner the main character. But this seemingly impossible scenario actually happened. It was executed perfectly in real life, and it forms the very core of our legal mystery today.
Section 1. A bizarre legal loophole.
We're going to completely unravel the incredibly strange sequence of events that led a group of defendants to legally own the very case that was filed against them. We'll look at the rules they used and the trap the plaintiff accidentally fell right into. So let's set the scene. The year is 1987. A man named Paulus Philippus Brummer launches a damages claim. He claims a contract was repudiated, which essentially means he's accusing the other party of walking away from their agreed-upon obligations and just refusing to fulfill their end of the deal. Because of this, he sues the Nylstrom Hotel CC, along with David Gorfil and his father. At this point, it's a fairly standard business dispute. There is absolutely nothing out of the ordinary about this initial lawsuit.
Section 2. How the debt started.
Now, as any lawyer will tell you, trials can be incredibly unpredictable. What started as a standard claim shifted dramatically, and a mid-trial victory for the defendants ended up setting a massive, totally accidental trap for our plaintiff, Mr. Brummer. So the crucial point is this exact number right here, 52,436 Rand and 48 cents. In September 1991, at the closer Brummer's case, the trial judge absolved the defendants from the instance. That's a piece of legal terminology basically meaning David Gorfil and his father were officially let out of the trial at that specific stage. And because they were let out, the judge awarded them their legal costs. This single unpaid legal bill of over 52,000 Rand owed by Brummer became the domino that toppled his entire case.
Here's exactly how that sequence played out to create the trap. Step 1. The Gorfils are absolved from the trial in 1991. Step 2. Brummer is officially ordered by the court to pay their legal costs for having to defend themselves up to that point. Step 3. Brummer fails. Whether it was a sheer inability to scrape the funds together, maybe an act of defiance, or just a failure to grasp the severe legal reality of an adverse cost order, the result was exactly the same. He simply doesn't settle the debt, leaving him with a massive liability he either can't or won't clear. And this leads to a brilliant and frankly ruthless legal maneuver by the defense team. The Gorfils wanted their money. The court said they were owed it, but Brummer wasn't paying. So they started looking for any assets they could grab to force the payment. They quickly realized Brummer had one highly specific asset they could legally attach and seize to satisfy his debt, his right to sue them in the pending, ongoing case against the hotel.
Which brings us to the ultimate climax of this loophole. In March 1993, an execution sale is held to sell off Brummer's assets. An execution sale is essentially a public auction. When a court orders you to pay a debt and you don't, the sheriff seizes your property and auctions it off to the highest bidder. In this case, the property was the lawsuit itself. And guess who buys it? Gorfil Brothers Investments, a company whose sole shareholders and directors at the time were David Gorfil and his father. They literally bought the lawsuit against themselves with the sole, explicit intention of shutting it down forever.
Section 3. The constitutional question.
Brummer naturally fought back against this maneuver. He eventually claimed this was a total abuse of the court process and against public policy. This shifted the gears of the case from a simple commercial contract dispute to some incredibly heavy constitutional arguments. Was this sneaky move actually allowed under the highest law of the land? Enter Section 34 of the South African Constitution. This section guarantees the fundamental right of everyone to have disputes resolved by the application of law in a fair public hearing. It's the bedrock democratic guarantee of access to the courts. So, I ask you, does a defendant buying someone's lawsuit specifically to silence them violate this fundamental democratic protection?
And this brilliantly illustrates a massive hurdle for Brummer: retroactivity. The incredibly sneaky execution sale happened in March 1993. But South Africa's interim constitution didn't even kick in until April 27, 1994. The events that completely destroyed his case happened before the new constitutional protections even existed.
Delivering the unanimous judgment for the Constitutional Court, Judge Yakub relied heavily on the Duplessis precedent. This precedent established a clear rule that the interim constitution ordinarily has no retrospective effect, meaning old, finalized sales can't be undone unless the enforcement of those previously acquired rights would be so grossly unjust and abhorrent that they cannot be countenanced by a democratic society. The court found absolutely no such extraordinary circumstances here. Why? Because this wasn't some deeply entrenched historical injustice. This was, at its core, a commercial transaction, a clever legal maneuver over an unpaid hotel bill.
Section 4. The ticking clock. Let's move to and see how this builds, because beyond the deep constitutional theory, we have to transition into the gritty procedural reality that ultimately doomed Brummer's entire effort. It wasn't just the law that was against him, it was the calendar. He was simply too slow. Because Brummer was late in filing his appeals, he had to apply to the Constitutional Court for condonation, which is essentially asking the court for a legal pardon for being out of time. To grant this pardon, the court requires it to be strictly in the interest of justice. They look at rigorous factors to decide this: the extent of the delay, the prospects of success for the appeal itself, the prejudice caused to the administration of justice, and crucially, the reasonableness of the explanation for the delay.
Now, what's really interesting about this slide is how it visually proves a series of egregious, unexplained delays by Brummer at every single stage of the appeals process. The sale of his lawsuit happened in March 1993, yet he did absolutely nothing, even though he had been served with the writ of execution. He waited over 2 years, until May 1995, to finally sue to stop the sale. He then filed his petition to the Chief Justice out of time in November 1996. And this final application we're talking about to the Constitutional Court, it was filed in December 1999, more than 9 full months late.
Section 5. The final judgment.
By the time this case finally reached the Constitutional Court for a decision on March 30, 2000, the patience of the justice system was utterly exhausted. The court pointed out a staggering reality. 9 long years had passed since the trial court last heard evidence back in September 1991. Dragging a commercial trial out for a decade with any good excuse is severely detrimental to the administration of justice. Think about that for a second. Try to clearly remember a specific business conversation you had 9 years ago. How can a fair trial possibly resume when witness memories have faded for nearly a decade?
So, the outcome was definitive and unanimous. The Constitutional Court ruled against Brummer. The delays were simply too extreme, his conduct was far less expeditious than expected of any litigant, and there was no special reason given for why he should be allowed to pursue a claim a full decade later. His application was dismissed summarily on the affidavits, meaning the judges ruled purely on the submitted paperwork without even needing to host a full oral hearing. Granting him a pardon for his delays was entirely against the interests of justice. As a final procedural wrap-up to the saga, the application for condonation was dismissed with no order as to costs. Judge Yakub noted that this is standard practice for the Constitutional Court in applications that are dealt with summarily without calling for oral argument. So, in this final battle, while Brummer lost his case permanently, neither side was hit with a new cost order. The case was finally over.
Which leaves us with this final provocative thought. If justice delayed is justice denied, at what point does the clock run out on constitutional rights? Brummer may have had a truly fascinating theoretical argument about his fundamental right to access the courts under Section 34, but the unyielding balance between strict procedural deadlines and fundamental rights meant his time simply ran out. Procedure matters just as much as principle. Thanks for joining me on this explainer. I really hope it gave you a brand new perspective on how timing and procedural strategy can completely rewrite the end of a legal battle.